Attorney generals from 25 states filed a federal lawsuit challenging the Environmental Protection Agency's admission rule for coal and gas-fired power plants. They argue the rule ignores previous court rulings, would force plant closures, and exceeds the agency's authority under federal law. The 25 petitioners asked the U.S. Court of Appeals for D.C. to declare unlawful and vacate the EPA's stringent new rule for fossil fuel power plants. The rule requires existing coal and gas-fired plants to either capture smokestack emissions or shut down. The EPA's rule marked the first time the federal government has restricted CO2 emissions from existing power plants, authority that petitioners argue the EPA does not have. They also noted that Congress has not yet granted EPA the statutory authority to remake electricity grid, meaning the agency cannot sidestep Congress to shutter existing fossil fuel power plants. The states also argue the EPA rulemaking defies the Supreme Court decision in West Virginia versus EPA. In 2022, the court warned EPA it should not use a narrow regulatory provision to, quote, force coal-fired power plants into retirement en masse. The EPA's final Clean Air Act rule is slated to take effect beginning in 2032.